There's been quite a lot of back and forth on the legal front as far as yung I mean, I'm sure you've heard, nag-file ng TRO si Atty. Torreon to prevent any move or action on the part of the application of an arrest warrant through the Interpol. That's one. The other hand, meron pang isang petition requiring the government to disclose, or the ombudsman to disclose whether or not there is already an arrest warrant. Let me ask you first about the first one, yung TRO, to prevent the application of or enforcement of any arrest warrant against Bato de Rosa. How does that work? Can you TRO something that maybe has not yet happened or has not yet been issued?
I presume this was filed before the Supreme Court.
Yes,
because
sir.
they have, in fact, it was pending petition on the arrest of Mr. Duterte. But yes, I do agree with you, Ed, that something hypothetical cannot be a subject of a TRO. In fact, there's actually no actual case or controversy as of the moment because there's still no official copy of that ICC arrest warrant. In fact, even the spokesperson of the ICC has stated that they don't have any information on that. So anything hypothetical cannot be a basis of a TRO application.
Hindi pwedeng preemptive.
Kasi pwedeng preemptive, kasi nga, anong i-restrain, You cannot restrain something that has not yet happened or is still hypothetical,
Yes, sir. But let me be the devil's advocate here. Kasi what if I want to restrain you from releasing an arrest warrant? Hindi ba pwede yan?
Well, that's very, that's very out of the blue. Why? Because in fact, the institution who allegedly issued the arrest warrant is an international organization.
Well, that's also
the ICC, wherein the Philippines has no jurisdiction at all.
Okay.
And then, of course, the big debate there is whether it's going to be extradition or surrender. But mukhang extradition is not an option kasi hindi naman sovereign state yung ICC. So it will just be surrender, and that question lies on the executive. Is that correct?
Yes, I agree with Gina because I've been stating this, that in fact, any extradition request is by a state. And in fact, even the rules on extradition proceedings that was issued by the Supreme Court last October defines extradition process as involving a requesting state. And yes, the ICC is not a state, it's an international organization. Secondly, if it's not a state, an international tribunal, the legal basis for surrender, which is in Section 17 of RA 9851. And it's the same process that was used by the Philippine government to surrender Mr. Rodrigo Duterte to the ICC. So we have the law and we have state practice.
But it's exactly that process that's being questioned now at the Supreme Court, right? Do you think that matters? Do you think that gives it any weight, the fact that that process is being questioned?
Well, it was questioned, Regina, for the arrest and surrender of Mr. Duterte. But if we will just look at the previous decisions of the Supreme Court, and if it will just be consistent with these previous decisions, it's already moot and academic. Mr. Duterte is already outside of the jurisdiction of the Philippines, is already in the custody of the ICC. And the ICC already made public pronouncement as to Mr. Duterte's being in its custody. So if the Supreme Court is consistent, it should actually just dismiss this petition for being moot and academic.
Right.
Why do I say this, Regina? Because that was the same tack that was used by the Supreme Court when it actually dismissed our own petition challenging the ICC withdrawal without Senate concurrence.
No, I meant, will that have any bearing on Senator Bato de la Rosa's case? The fact that that same process is being questioned at the Supreme Court?
Well, I think it will have no bearing on Mr. Bato de la Rosa's case because it does not even involve him. The petition that he filed together with the family of the Dutertes is actually on Mr. Rodrigo Duterte's arrest. not on his potential arrest by the ICC, not on his potential surrender because of ICC arrest warrant. So it's a totally different case.